Okay, good morning, everyone, and thank you for joining our online presentation. We will allow for opportunity for those of you who have questions. You will be able to ask any questions that you may have at the end of the presentation. We just ask that you please keep your Zoom on mute so that we don't hear your background. You are more than welcome to chat in the chat box, and we'll just kind of jump right in with Max Shoemaker. Max, thank you so much for allowing us this time to learn with you about the basics of an estate plan. And if you can please just introduce yourself. Thank you.
Absolutely. Well, it's a pleasure to be here and it's a pleasure to meet you. I encourage you to turn on your cameras if you are able to do so, so I can see those lovely faces and see who I'm talking to. So, like Michelle had said, we're going to just talk about the basics of an estate plan. Hopefully, we can get through. I don't plan to take the whole hour. I'm not going to take a whole hour of your time, I don't think. Um, so we'll just jump right in. Um, so a little bit about me. Um, I am an experienced California attorney. I've been working in law for over 10 years. I've been officially barred for the past for about 3 years. And I come from a background of contracts, and I became a part of Channel Islands Law Group last year. I've helped out about 20 clients so far. I work, Channel Islands Law Group has been established for about 20 years. Uh, and between me and our other two attorneys, we have a lot of experience together. And even in the 20 plus clients that I've helped so far, I've dealt with a multitude of different family structures, different assets, and I'm more than willing to help any situation that comes my way. Um, about me personally, I'm born and raised in San Diego County. I moved up to Orange County back in 2010. I met my wife when I was in college at Cal State Fullerton. Go Titans! And we have two lovely children. You can probably find us on weekends. You can either see me running around Huntington Beach long distances, or you can see us checking out the local cool new restaurants with me trying to wrangler my 4-year-old and while holding my 1-year-old. So, so estate planning can be a very overwhelming project to undertake. I do understand that. And we're here today to answer questions and discuss commonly used documents and explore the types of people that can benefit from a comprehensive estate plan. So first, let's take a look at some common questions. What is an estate plan? You've probably heard the term estate planning, but maybe you're unsure exactly what it means. So simply put, estate planning is a comprehensive plan that addresses how you and your stuff are to be managed. The plan covers what is to happen to you and your stuff if you're unable to manage your own affairs, which we also call incapacity, or at your death. What if I don't have an estate plan? If you become incapacitated, you're unable to manage your own affairs, and uh, having created an estate plan, your loved ones are going to have to go to probate court and ask to have someone appointed to make financial and medical decisions on your behalf. The judge, if it's you, the judge may not appoint the person or people that you might have necessarily appointed yourself. This process of doing this can be very costly, time consuming, and it would become a matter of public record because it would be in the court. Also, when you die without an estate plan, state law determines which of your family members will receive your money and property and how much they will receive. This is determined by statute and uh, may not be the outcome you've chosen. So here I put in the chart of what the California statute structure is for if you do not have a will or anything in place, what happens to your property. So you would be here, person. And so first it goes down. It would go to your children, it would go to your grandchildren or great grandchildren. If you don't have any descendants, it goes up. So it goes to your parents. If none of your parents are living, it goes down again. So then it would go to your siblings. Some people are okay with this, but every family is different, and some people don't have the best relationship with their family, either with their parents or their siblings. So if that's the case for you, or even some children, you have to have some document in place that goes against this structure. Otherwise, the state won't know, and they will just give your assets or money to people that you may not choose yourself. Special note, some accounts and other assets, such as life insurance, can pass on at your death if you filled out a beneficiary designation. I think most people on this call have probably seen that in some respect at some point. Other properties, such as real estate, business interests, tangible personal property, and others, will require the court's intervention in probate and are subject to the state's default plan. So, what is probate? Probate is the court process of determining whether a person, the decedent, died with a valid will, who will wind up the affairs of the decedent, who will receive the decedent's money and property. So everybody talks about the horrors of probate. What's wrong with probate? Why do I want to avoid the probate court? Well, probate courts are impacted. We're in California. We're the most populous state in the union. So it's very time consuming. In California, you would be lucky to have a probate that is a year long. A lot of times they're 2 or more or over 5 uh, if you have, depending on how big your estate is, and if you have family members that are fighting over it. It's expensive. The cost of probate is typically tied to the value of the estate, and it usually ranges between 2 to 4% of a gross estate's value. So if you're a homeowner, that's tens of thousands of dollars. The other reason is that it's a matter of public record. So why does that matter? One, it's a court. So the easiest place for people to contest their inheritance is in front of a judge, opposed to a private document, which I'll get to a little later in the presentation. Also, because it's a public record, it's easier for creditors of your estate to see it. So, because a typical way of how the probate process works is that any known creditors that are out there, the court goes and says gives notice to all of them that, hey, you might be a potential creditor, and then they can come and try to receive a piece of the estate before distributing to your beneficiaries.
Hey, just really quick, Max. If it were to go to probate, they do have to put an ad in the newspaper or make some sort of public statement or acknowledgement of the passing of that person, which is how many creditors do find out about the debt, correct?
Right. Yeah, that's a very typical practice for probates. So, um, moving on. So, okay, so the next question that I get a lot, especially when it comes to a home, can I just add someone as a joint owner? So, in order to avoid probate, could you add people as a joint owner to an account or a home so that they just receive immediately the asset? And the short answer is yes, you can do that. But let's take a look at that for a second. By adding a child, a sibling, or a friend to an account or a piece of property, you're subjecting these accounts to your new co-owner's creditors. So if you're married, having things jointly makes a lot of sense because your estate in California, community property, for the most part, is joint. But after the first spouse passes away, then then it's just one person again, which could be subject to probate. So some people might add their sibling or their child or something to that matter. Here's the issue of doing that. It could be subject to their creditors. So if there's a judgment against the co-owner of the account, the creditors could access that account. In addition, as a co-owner, they have all the rights of a co-owner, so they can drain an account if they wanted to. And lastly, depending on the value of the account or property, you should consider some gift tax consequences. In 2024, you can gift an individual up to $18,000 without having to file anything with the IRS. You've how, However, if you've made any previous gifts in the same calendar year and the total is over 18,000, you'll have to file a gift tax return with the IRS. So when you add someone as a joint owner to a large asset that's over that amount, it could be considered a gift and it could be considered taxable. Can I just complete a transfer on death or payable on death designation? Um, some accounts allow you to name a transfer on death or payable on death beneficiary so that when you die, the account will either be transferred or paid to that person without court involvement. And while these designations can be incredibly efficient at transferring your account to the beneficiary upon your death without court intervention, it could be dangerous depending on the nature and value of the account. So any distribution of an account to a beneficiary makes it the sole property of the beneficiary. And once it's in the beneficiary's hands, it becomes vulnerable to any claims by creditors, judgments, or divorce proceedings. The divorce proceedings one is a little, I think that, um, someone had put that as a note for me to mention. In California, it's not so much the case. Um, just a bit note on divorce in California. California is a community property state. And so anything that's purchased during marriage is presumed to be community property. An exception to community property is if you receive an inheritance or a gift. Even if it's received during marriage, it can be considered separate property. The problem that a lot of people fall into is that they might commingle their separate property with their community property, either in accounts or by pooling together to buy a home, and then it becomes a little murky. So, um, so that's something to keep in mind when thinking about um, like giving to somebody. Uh, if if your child is married to somebody and it doesn't seem to you like the marriage will last, there are mechanisms you can put in place. And let me get into that for a second. So how do I avoid, oh, let me get back on track. It will come up again. That's what I'm saying. Um, how do I avoid probate?
A lot of good stuff here, Max. There's
I know.
easy
It's a
to
lot of
get back.
information. I understand it's a lot. Um, Feel free to stop me anytime if you want to delve into something or ask a question. I'm happy to do it that way as well.
Okay.
But I will keep going for the sake of this. And if anything sort of strikes you as uh, a topic where you might want to ask a question, I can address it in a moment.
Okay, and
So, okay.
just really quick, for the folks that joined, that recently joined, if you do have any questions, just go ahead and send a private message or in the group chat. You can ask your question there, and then I will kind of be the moderator and read the questions that you have. So it is important that we address any questions that you may have as well. Thank you. Okay, go ahead, Max.
Yeah, no problem. And that's a good way to do it. If we can compile questions and go through them at the end, that might be the best way to go. Okay, so how do I avoid probate? So you're probably wondering how to avoid probate if you're advised that adding people as co-owners or using beneficiary designations isn't the way to go. So um, if we're advocating away from that, what can you do? Well, there is a way that you can transfer your accounts and property out of your name while still retaining all the benefits of being able to use all your assets during your life. And that is a revocable living trust. Um, I'm sure many people here have heard of this term before or have friends who have a trust. But for those that don't, trusts are not just for the uber wealthy. people. They're for everybody, and they should be for anybody who owns a good amount of property. Or if you have any type of um, beneficiaries that you don't really feel that you would rather choose than uh, a estate plan that the state has laid out for you. So first thing you do when creating a living trust is you establish your trust. In this trust, you're going to name a trustee, someone to follow the someone who's going to follow the instructions laid out in the trust. So in the beginning, that's you. As the person who creates the trust, you are both the grantor and the trustee, the first trustee, which means that you have the power to control all of the trust assets. You have the ability to amend your trust. You even have the ability to revoke your trust. Um, After you can establish who would take over your duties after you pass away. For married couples, there's typically one trust, and they serve together as co-trustees while they're alive. And when one passes away, the other one is the sole trustee. And after both spouses passes away, the trust becomes irrevocable, which means that nothing in the trust can be changed, and the assets have to be distributed in the manner that it says in the trust. And for that process, you nominate a successor or multiple successors to do that. So next, you're going to determine who you want to be, who you want your beneficiaries to be. Um, while you and or your spouse are alive, that is both of you, if it's a community property joint trust. Otherwise, it's just you. And after you pass away, it's whoever you nominate it to be. It could be your children. That's most common. Um, but I've worked with clients before who have wanted to disinherit children. It's a common request. Maybe for one reason or another. Maybe they became a drug addict and they left your life, or whatever situation where they became estranged. If you don't have it written somewhere that they are disinherited, then they are entitled to receive whatever share of the estate they would. So creating a trust, you get to name who those beneficiaries are. Children, other family, friends, grandchildren, charities. Oop, that just kind of came up there. Okay. So the other important part of creating a trust is retitling your assets into the name of your trust. And that adds them into this bucket. So accounts and property that include your home or other real estate can definitely and should definitely be added to this bucket. However, retirement accounts are not typically added to this bucket. One, you can't retitle a retirement account into the name of a trust. It's just something you can't do. But what you could do is you can make the retirement proceeds go to the trust by naming the trust as a beneficiary. We generally recommend that if you're married, your spouse should always be the first primary beneficiary. And then you would have your trust listed as your contingent beneficiary. And that has to do with the laws in place where I believe the rule currently is that your spouse is able to take out your estate, and there isn't a cap on how many years it takes. But if it's anyone other than your spouse, um, it's limited to 10 years or so. I'd have to double check, but there's a law in place that caps it at a certain point in time.
Hey Max, I have a quick question. So if a homeowner, if let's just say they have joint tenancy with their spouse, but they
Mhm.
were to put the property into a trust,
Yeah.
do you basically like convey the property into the trust and record that deed with the state, or I'm just kind of curious how that
Yeah.
works.
Absolutely. So yes, we do what's called a trust transfer deed. And so it takes the property out of however it's previously held, whether it's as a single person or as you're saying, like as joint tenants or joint tenants with right of survivorship or husband and wife as community property, however it's titled. And we transfer that into the trust and we record it with the county. And uh, and if you are thinking about property taxes and change of ownership and reassessment, I can uh, assure you that property transfers into a trust, as long as the owners and the number of owners are the same of both, it will not trigger a change of ownership and it will not trigger a property tax reassessment. So that's so if you're in your example, if you're a married couple and it's transferring to uh, your joint trust where both of you are the trustees, then there is no change of ownership, there's no reassessment, and it's a deed that is filed and recorded with the county. And when we do that, it takes maybe a day or two, and the deed's recorded in the trust name.
Okay.
Where was I? Okay. So as I was saying, retirement accounts aren't included, but you could name them as a beneficiary designation. Okay, so how does the trust accomplish my goal? As we mentioned earlier, the key to avoiding probate is to ensure that you do not have any accounts or property owned solely by you upon your death. So if your trust has been properly funded, you'll die without any accounts or property in your name, but you will have received the benefit of those accounts and property during your life. What I'm saying here is that even though these accounts may be changed into a trust's name, you will be the trustee of your trust. So you're going to have full control over all your assets. Nothing in your day-to-day is going to change while you're alive. So upon your death, the successor trustee will inventory the accounts and property that make up the trust. Next, the successor trustee will distribute the money and property to the beneficiaries according to the terms you've established. And all of this is going to occur without any court involvement. A trust is a private mechanism. It will not be filed with the court. There is no information about your beneficiaries, about your assets, or about the mechanisms of this trust that have to be filed in court in California.
Can the trustee and the beneficiary be the same person?
Yes. And that's basically how it is during your life. So when you form your own trust, you wear three hats. You are the grantor because you are the one who is putting assets into the trust and creating the trust. You are the trustee because you can control all the trust. You can amend the trust. You can distribute assets the way it's supposed to be distributed. And you're the beneficiary because during your life, you are the one who's benefiting from the trust. So let's take a look at some special cases. People needing special consideration. Minor children. So a really important reason to make sure you talk to an estate planning attorney at some point is if you have children, minor children specifically. Um, because what happens when you pass away and you don't have any planning in place is that the court has to determine who is going to be the guardian of your children. And they might choose the same people that you do, or they might not. Or you might have multiple family members pleading their case to try to gain custody of your children. So how do you avoid that? You can plan for that in an estate plan. That's something that usually is put in a will that is filed with the county. Um, and um, that would determine and that gives you the power to be able to determine who your successor guardians are if anything ever happens to you and or the other parent of the child. Um, so here it talks about temporary guardians and permanent guardians. So temporary guardian might be somebody if, for example, you and or your spouse, other parent of the child, are on a vacation and something tragic happens. Uh, but maybe your permanent guardian, your first permanent guardian, is located on the other side of the country. Well, you can have a temporary guardian that you nominate who is close by, a neighbor, a friend, a family friend, who can take immediate custody of the children until the permanent guardians are able to come and take actual custody. And then obviously I have permanent guardian. That's who you would list in your will. That's who you can nominate to be able to be the guardian of your children that you choose.
And
Protecting your inheritance. Oh, go ahead.
I was just gonna quickly say, like, having gone through that process myself with my adult, sorry, I can't talk today, with my adult son. He was 25 and I had to go through the court process, but rather than being his guardian, I had to get conservatorship. And honestly, if you can plan for that, like, the sooner the better, because it can be it can be very emotionally draining, very detrimental, also very costly. So if you do have smaller kids, like, start to think about these things. I know they're very uncomfortable, but
Yeah.
life just throws balls and curveballs at us, and you just kind of have to hope for the best but plan for the worst. So start to think about these things. If you have grandchildren, talk to your children about, like, getting these established while they are in a position to do so.
Yeah, I mean, the worst time to make any of these decisions is when a crisis is already happening, right? And just to echo that sentiment, when my wife and I were creating our trust and we were making these decisions, it was very difficult because with us, it'd be, my parents or my in-laws or different family as far as who would be the people to take custody of our children. And making those decisions is hard, but I would rather make that decision than a court because I already know at least two or three family members who would probably fight for it, and they shouldn't have to. Um, so aside from the guardianship aspect of planning for your children, we talked about inheritance. So, a trust is the best way to go to plan for your children's inheritance because you can modify it so much. If there is no will or, um, okay, I see a hand up from Anita.
Okay, so
You have a question?
Anita, if you can go ahead and unmute yourself and ask your question.
Hello, Anita? Okay, well, if you have a question, you want to type it in the chat and I'll just keep going. Oh, there you are. Hello?
Can you hear me now? Can you
Yes.
hear me now?
Yes.
Okay, I apologize. I was a latecomer on the line, but I do have a question. Let's say, for instance, we do have a teenager,
Okay.
and their father has never been involved into their life. Something so happened to me before she turned 18. When we're doing these documents, and do we have to, let's say we were trying to leave the child to somebody else, do we have to list that their dad is there still? Or do we have to list that their can take them?
Do you have uh do you have sole custody?
Yes,
Okay.
For the court.
Yeah, like it's ordered by the court to have you have sole custody.
yes.
Okay. Yes. So then if you were to create an estate plan and make these nominations, you have the authority to nominate someone other than the father.
Okay. Okay, I just wanted to verify that.
Sure.
And let's say that we have 4 children and we had divided that everything as far as life insurances go, the property. Do those 4 children all have to be present to do anything with the property?
No. Well, so you mean like do all 4 children need to be involved in like splitting up the property?
Yes.
No. And so that's sort of the beauty of this, and that's what I'm going to get into. So, um, with so just as I was going to say, if you have a will or you have nothing, the only way you can distribute to children is outright, um, when they're 18. So, I don't know about any of you, but I wasn't the most sound financial decision maker at the age of 18. So, a lot of times in a trust, you can make it so that they don't receive anything until they're 25, or you can break it up. I have it set for my children that they receive their inheritances, a third at 25, an additional half at 30, and then the remainder of it at 35. And if depending on how much you have, the trustee can manage it in an account. They could give the child um, income from the account in the meantime before those thresholds. Um, and of course, there's also, we usually draft our trusts to say that if anything happened to you, but your child needs money for college or any type of medical emergencies or expenses. The term we use is health, education, maintenance, and support. If it falls into those categories, they can go to the trustee and ask for that money, and the trustee in their discretion will give a reasonable amount of money to do that. That's just an example. You can do all sorts of things, and that's why you want to, and that's the biggest benefit to having a trust when you have a lot of children, is that if you want to split up, give specific things to specific people, or maybe split your estate in a way um, that's unequal distributions, you can do that with a trust. You can also do it with a will, but then you still have the risk of probate. And so that's sort of one of the big benefits here.
Thank you for your question, Anita.
Yes, thank you, Anita. That was a good question. So those who need help managing money. So that's a special type of case. Sometimes some people are good with money, some people aren't. And that sort of goes into what I was just mentioning as far as setting, you could set specific ages for receiving an inheritance. You can also set conditions. Um, you have to be clean and sober for 2 full years. And you have to test for the trustee every month that you're clean. Or you have to present your, 2-year clean chip to the trustee to receive any bit of your inheritance. There are different conditions you can put in place to receive an inheritance that you can't do with a will. So those are some things to keep in mind, or keep it in trust for the entirety of their life. That's another thing that you can do. Blended families. This is always a fun one. It's always one of the, sometimes if I'm working with a client or married clients who are in their second or third marriage or so, and they have children from previous marriages, something I might ask in a consultation is sort of like, what's the drama, right? What is, are there any family members that don't get along? And so if you fall into this category, you're definitely going to want to talk to an estate planning professional, because you might want to put in certain mechanisms in place and structure your estate in a way so that certain people get certain things and others don't. Also planning for things like prenuptial agreements or divorce settlements, and making sure that that's all those types of factors are worked into your comprehensive plan. Special needs. So this is a class of people that would particularly not benefit from receiving an outright distribution. If you have any special needs family members that either currently or in the future would receive benefits from the government, if they received a big inheritance, all of a sudden it could disqualify them from receiving those benefits. So if you just have a will or you don't have anything in place, that's a problem. The way the way we would recommend doing that is to set up a special needs trust, or a supplemental needs trust is actually a more accurate way to say it. And so a supplemental needs trust is something that would supplement their lifestyle, but it would not supplant their government received benefits. So I get this question a lot. I get some people who say, I have a special needs child. I heard about special needs trusts. I want to set one up. And I usually say, no, you don't. And the reason is because it's too early. A special needs trust is an irrevocable trust. So if you put money in there, it's gone. Like, you have no access or control to it. What instead I recommend is setting up a revocable trust, like I mentioned, a revocable living trust. But you take that family member's inheritance and you say, upon my death, a supplemental needs trust will be created to hold the inheritance for this person.
Hmm.
And that's what you do.
So basically,
That way, you still get the full benefit of flexibility of your assets while you're alive, and you know that your special needs family member is taken care of after you pass away, and they're not going to get disqualified from their benefits by receiving a large sum of money. Business owners. If you own a business, an LLC or a corporation, you can assign your LLC membership or your corporate stock into a trust. And this might be something to think about if you haven't really thought about succession planning. A lot of business owners, they go into business, they're really just thinking about, I want to do this thing, but they don't think they need to also think about, you know, what happens if I pass away? Is it going to my other business partners? If this stuff isn't fleshed out in their corporate documents, you can flesh it out here. If you have a family business, putting in terms for your business interests in a trust makes a lot of sense. Moving on, pets. So I'll tell you just a bit of personal stuff on my life. Last year, my sister passed away, and she was very young. She was 35, and it was very sudden. She just passed away in her sleep. She had a cat. We had no idea what to do with her cat. We lucked out. We spoke to somebody who was willing to take care of the cat, but not a lot of people, that was a lucky situation. It's hard to find people who are willing to take on the responsibility of being a pet owner. Something you can do, you could create a trust for your pet. That is something that's recognized by California. That is something you can do. You can also designate where your pet would go if you pass away. Specifically, I have a client who has a couple of dogs and has talked to a friend about if anything happened to him, if he would take care of the dogs. And so he's leaving the dogs and then a lump sum money gift of like $5,000 to that beneficiary. Why would you want to create a trust if you could just leave them a lump sum? Well, once you send them a lump sum, maybe it'll go towards taking care of the dog, maybe not. So that's why you have trusts, is to sort of have some level of enforcement. Other estate planning documents. So far we've talked about wills and trusts, which cover death. But it's also important to think about a financial power of attorney, because maybe you haven't passed away, but maybe you have dementia or Alzheimer's, or you get into a debilitating accident and you're not able to make decisions on your own behalf. It might be worth, I mean, we recommend, of course, having these documents in place, just because you don't know what the future holds. And if you are laid out in the hospital, it might be nice to have somebody who's able to access your accounts and pay your bills for you while you're in the hospital. Or, if you have Alzheimer's, for someone to be able to pay those expenses and take care of you for your benefit. In California, we also have advanced healthcare directives. So this is basically a medical power of attorney. A financial power of attorney is for finances. A medical power of attorney or advanced healthcare directive is for making medical decisions. In this, you can instruct a hospital and healthcare agents who you nominate, people that you choose, how you want to be treated if you're on life support, or who to nominate, who to make these medical decisions if I'm unable to make these decisions myself. I end up in a hospital. If you don't have these documents in place, I encourage you to do this, because another crazy thing that happened in my life last year was that my best friend got in a very bad motorcycle accident. And he's actually in surgery today for like his 20th surgery on his legs. You just don't know. And when it happened last June. There were people there at the scene who were able to rescue him and get him to the hospital. But when they did, they had no idea what to do, because he didn't have any type of documents in place, and they had no idea who to contact. Like, an advanced healthcare directive isn't just beneficial for, saying who is in who. It's not just useful for your family members. It's also useful for the hospital. If there's an advanced healthcare directive that people know about, then it can be presented to the hospital. They'll have all the contact information of who they need to contact, and any of sort of the bigger decisions in place as far as how they want to be treated. Are they going to be an organ donor? Are they going to be, do they want to be resuscitated? Those types of decisions. These are all parts of a comprehensive estate plan. So, what should I do next? Well, the short answer is that what you should do is you should call me or contact me, set an appointment. If you scan this QR code, this goes to my calendar, and you can set a time where we can chat and discuss your specific situation. I usually, when I work with people, I do a comprehensive estate plan. And if you have property, I don't always, but I'm mostly, in 99% of situations, recommend informing a revocable trust. And in doing so, I also will draft a pour-over will, an advanced healthcare directive, and a power of attorney. And I include that when I work with my clients, because all of those documents are so important, and they all work together to take care of you and your loved ones.
And just really quick, Max, there's two things I would like to highlight. So let's just say you don't have a trust, but you do have a will. And can you quickly highlight with the will, let's just say a parent were to pass away and there were 3 siblings, and one of the siblings wanted to contest the percentages or whatnot that they were being left as an heir. I know you had mentioned to me in a private conversation that just a regular will can be contested with the court, but it's a little bit more difficult to challenge if it's in a trust. Is that
Yes, correct? It is correct. Courts are meant to hear all sides. So it's in front of a judge. And if people are making multiple claims on how much they deserve or how much they're entitled to, for whatever reason, it's easier to make that case in front of a judge. Let me give you an idea of sort of how these documents work together. So I had mentioned that when I do a comprehensive estate plan, there is a trust, a will, power of attorney, and advanced healthcare directive. Some of you might be asking, well, wait a minute, if there's a trust, why is there a will? Well, when you pass away, something needs to be filed with the county, and that is, and so that's a will. Now, the way we draft wills, if you have a trust, it's called a pour-over will. And so when you file that with the county, the only thing that that will is going to say is that this person passed away, this person is my executor, these are my children, just for documentary's sake, and then all of my assets in my estate are to be poured over into my revocable living trust, and it gives the name of the trust. It does not say anything about your assets. It does not say anything about your beneficiaries or the percentages. And it does not say anything about the mechanisms of the trust. And that's what's filed with the county. After that, the trustee should call me, person who drafts the trust, and I will walk them through the process of making sure we get the death certificates together, we take an accounting of what all the assets are, and distributing those to the beneficiaries by what the trust says. All of that is done outside of court. So you can see how, if that's the process, it's harder for people to come out and contest it. They still can. I mean, it's not bulletproof. There are certain situations where you might, where someone might try to challenge an estate. For example, if someone is on their deathbed and they decide in that moment, it's probably a good idea to have a trust. So, so then people are like rushing to the hospital, rushing to draft it, trying to get them to sign. Maybe he or she can sign, maybe they can't. And then you have this sort of question of capacity in the air. So you might have people coming out of the woodworks to challenge the capacity of the person who signed that. And in some cases, it's rightly so. And in some cases, they were lucid. There was a number of witnesses that all knew and felt that way, and it's fine. So those might be a situation where a trust can still get challenged. But for the most part, that doesn't happen very often.
Okay, perfect. And then Doreen asked, if you have a will, can you basically convert it into a trust?
Yes. So I would say, schedule an appointment with me, scan this QR code, get on my calendar, send me an email. And what we can do is we can set an appointment. I can take a look at your will, and I can either amend your will and also draft your trust, or I can draft a completely new will, revoke the last will, and make it so that all the documents work together.
And then I have another question. So let's just say there's a married couple. I'm picking on the married couples today. Let's just say there's a married couple, and for whatever the reason, maybe one spouse doesn't necessarily want their spouse to become the medical director if they were in a state of if they were incapacitated. In a trust, can you have a nominee other than your spouse as the directive of your medical and financial power of attorney?
You can. So I just want to make sure I understand your question. Are you saying that for medical decisions, do you want to have someone other than your spouse as your as the person to make those decisions?
Yeah, like say you wanted your child to be your child rather than your spouse.
Yes. Yeah, you can do that. And that's not really something that happens in the trust. That would only be in the advanced healthcare directive. But yes, that is definitely doable.
Okay.
But if you don't have anything in place, it's going to be your spouse.
Right, right.
So,
And it should be your spouse, right? But okay, well, are there any other questions out there? If not,
Yeah, this is Anita.
oh, yes.
This is Anita. So I'm in Colorado. So do you deal with people outside of California?
Good question. Unfortunately, I am barred in the state of California, and the way it works for estate planning is estate plans need to be made where you live. So if you live in Colorado, I can I can search for someone who is in that state and let you know. Otherwise, you have to find someone who's smart attorney in Colorado.
And do you have referral partners in other states?
I don't have one in Colorado specifically, but I can put my feelers out.
Okay,
And then the next question is, what does something like this run?
I get this question a lot, and I can't give any sort of answers without discussing your specific situation. It would be like it would be like going to MiChell and saying, how much does a basic house cost? Not like an extravagant house, but a basic house. Well, how many rooms does it have? Where is it? So it's just one of those things where, you need to know more specifics about a situation before quoting it.
Okay, and then one more other question. I see that the presentation is recorded. Is there any way that you can send that recording over?
Yes, so I will actually blast it out to everybody that joined. If you did not register through Eventbrite, if you can just shoot me a message either in the chat or let's see, there's one person on the iPhone. I'm not sure who that is, but everybody else, I do have your emails. I will send you a copy of this recording. And Max, would it be possible to send some of these slides that you presented to them as well?
Yes, I can do that. Actually, I just wanted to take a second. The other thing I will say about billing, normally our firm, we bill on a flat fee basis, and it is way less than what it would possibly cost to probate an estate. It's and we do it on a flat fee because we think that that's the most beneficial for our clients. Um, you know, Probate is based by percentage, and we keep things with just a flat fee. So it's usually, I mean, yeah, I wish I could give you a quote, but nothing I could give is necessarily accurate. And the reason I say that is because, I have, on one hand, it's like there's a single person maybe who needs to have these documents made. Um, and it's just a very simple process with their kids. They have one kid or they have two kids, and it's equal distributions, and it's really easy. On the other hand, you might have a married couple, and you think like, well, maybe they can have a joint trust, but really they can't. They're in their second marriage. They want to split their estate down the middle, so they actually need two trusts. But wait a minute, they also have community property. Oh, well, maybe they need three trusts so that they can have like it hold their community property and their separate property. So those are the types of things that can affect price and time in order to be able to put these plans together.
Okay.
So let's say that, I apologize. This is Anita again.
Yeah.
So let's say that, that you put these plans in place and you're single and these plans have been placed and it's going to your kids and stuff like that. And then you eventually get married, but you don't want any of it to change. Is that possible?
That's a good question. I think that I think that that's possible. Basically, the way it would work, I would say, is that if you have everything in place and you have your single trust estate plan and you want to keep it that way, you want to keep it separate, that's a good way to do it. It's just keep it all in that one trust. But if your spouse at that time, 5 years from then, you decide you want to go in together and purchase a property, you can sell whatever you have to do that. But if you're both going in together on a house, then it's community property at that point. And I'm just want you to know, I'm talking from a California standpoint because California is a community property state. I don't recall if Colorado is too or not.
No, Colorado's not.
Oh, it's not? Okay, so this might not apply then. But in California, if that were to happen, um, and both people went in together on a property, that's community property at that point. And I would recommend at that point that that piece of property be put into a joint trust for the two of them. And depending on what on their goals and what they want to do, I would recommend is, upon the death of one of them, the other one has the ability to stay in that house for the rest of their lives. And then after the second spouse passes away, it would be split 50-50, and 50% would go into the wife's trust and 50% would go into the husband's trust, because of course he is making the sensible decision of also having his own separate trust. And I would be and then the halves would be distributed how they want to their children in their trusts.
Okay, so as an example, I have mine set. Let's just say, as an example, I already have mine set. My property that I purchased on my own, all of my cars, all of my everything is already set in place. Then I decide to get married, and me and my husband decide to buy a property, but we agree on that property being 50-52 if he has children and I have children. Is that possible, or do you have to close out your original one and combine your original property with that other one?
No, you don't. Again, talking from a California perspective, I don't know what it is in Colorado. I don't know how it works with separate property states. And that's why I would recommend, if this is in Colorado, you speak with an estate planning professional in Colorado to be able to get a more accurate answer to that question. In California, no, that wouldn't be the case.
Okay. Okay. Well, thank you.
You're welcome.
Okay.
Thank you for your questions. I love it. Well, I guess I broke my promise. I was hoping to keep it before noon, but we're a little over. But if anyone needs to go, I understand. I thank you all for listening to my presentation. Please reach out if you have any questions or if you'd like to set an appointment. I'm available. And yes, I will. I'll either distribute the slides myself or reach out, or I'll work with MiChell to do it. So.
Okay. And then just really quick in closing, I do want to say, for those of you in California, something that I've started doing after meeting with Max and kind of learning more and becoming familiar with the estate planning, and from a real estate side, knowing how important having a plan, at least at the very bare minimum, having a will, but now learning the just like the forces behind having a trust. And I also see clients who in probate deals, like when those go through the court system, it's a lengthy process, and sometimes it can just be very draining on the families. It's very costly. So something that I started doing in California, because it's a greater price point here in California, is I team up with Max, and I'm able to put the property in a trust for you, and I absorb that cost through the purchase transaction, and that is something that I offer to my buyers. If you are in Colorado and if you are looking at purchasing, we can consider, I do have a couple probate or real estate attorneys, and we can kind of discuss that option, just depending on some variables. But I do want to throw that out there. So thank you so much, Max, for your time today. And I think moving forward, we'll probably do more of these workshops online. Hopefully we can do them in person at some point. But thank you all for joining. And if you have any questions, please feel free to give me a shout. Have a great day, everybody. Bye.
Have a great day.